Hello and welcome to BYJU'S Exam Prep IAS. Let's get started and look into the first article. The first article says some Raj Bhavans are on the war path. Let us try and understand what is this article all about. The article here is speaking about the confrontation between the governors and the state governments. The author here goes about explaining this tussle between the governor and the state government with the help of two recent incidents that have occurred, one in the state of Maharashtra, the other in the state of Kerala. Let us try and understand what are these incidents. First, let us take the incident that happened in the state of Maharashtra. What happened in the state of Maharashtra? There is the vacancy for the role of the speaker. So ideally what should happen? There should be an election process. The members should elect the speaker, and for deciding which is the date that the elections will occur, it is the role of the governor. So what is happening in this particular case? We have Article 178 of the Indian Constitution, which clearly says that the speaker and the deputy speaker of the legislative assembly, it says every legislative assembly of a state shall, as soon as may be, choose two members of the assembly to be respectively speaker and deputy speakers, and so often as the office of speaker or the deputy speaker becomes vacant, the assembly shall choose another member to be speaker or the deputy speaker as the case may be. What does this denote? This denotes that when it comes to the legislative assembly, we have two important roles. One is the legislative speaker, the other happens to be the deputy speaker. So this article clearly goes on to say that there has to be two positions. One is the speaker, the other is the deputy speaker. Elections will have to be conducted for the role of the speaker and the deputy speaker, and if this office lies vacant, so it is empty, there is no person, in such a case elections will also have to be conducted at a suitable date so that there is the speaker and the deputy speaker. But what is the issue in the present situation? The present situation is, as we just discussed, there is no speaker as of now in the legislative assembly of Maharashtra. So what should happen? Ideally, the governor should ensure that he sets a date for the election of the speaker, which means that when you look into Article 178 of the Indian Constitution, the Constitution neither sets a time limit nor it does not specify the process of the elections. It ultimately leaves it to the legislature to decide how these elections has to take place. It only says that there shall be a speaker and such a process of election as soon as may be. So it does not prescribe a time limit. It does not say that this process of election should be completed in 1 week, it should be completed in 15 days, it should be completed in 1 month. So the Constitution does not give this particular intention or the time limit, but it leaves it to the legislature to select the mode of elections and also prescribe the time limit. So the Constitution does not in any way set a time limit nor specify the process for these elections, but instead leaves it to the legislature to decide how these elections will have to be conducted. But remember, there is something called as defining the date, which means when this election for the speaker will have to be taken up. So we have the president who decides it at the Lok Sabha. So at the Lok Sabha, we have the president who decides when the elections to the speaker will happen, and at the state level we have the governor who sets a date for the election of the speaker. Does this mean that the governor or the president have the discretionary power to select this particular date? No, this will happen as per the recommendation of the cabinet. Also remember, it is the governor who sets a date for the election of the speaker, but when it comes to the deputy speaker, it is the speaker who decides the date for the election. This is very important from the preliminary examination point of view. When it comes to the speaker, it is the governor who sets, but when it comes to the deputy speaker, it is the speaker who decides the date for the election of the deputy speaker. So what is the case here? Ideally, what should happen? The governor should fix one of the dates where the elections for the speaker will take place, where the members assemble and these members will vote and select their speaker. That is what is the prescribed rules. But what is the present condition here? What happens in the state of Maharashtra? We have the ministers of the government. They approach the governor. They request the governor that, dear governor, we have selected a date. Please ensure that you give this particular date for the assembly of the members so that the speaker could be elected. So they approach the governor. They request the governor that please ensure that you issue a notification on such and such date so that members could assemble and select or elect their speaker. This is what is the request made by the ministers. While all of this was happening, there were other changes that were also introduced by the government of Maharashtra. What does the government of Maharashtra do? It brings in changes within the rule book of the assembly. What does the rule book say? It says, as of now, in the existing procedure, we have the secret ballot by which the speaker is elected, but they change this rule and they say that in the near future it can also be open ballot as well. Why do they come up with such an introduction? That is because they also feel that if there are MLAs who are actually opting for a speaker, they may also cross vote as well. They might vote to another candidate as well. In order to prevent it, the existing regime which speaks about the secret ballot will be replaced by the open ballot. So this is the new rule that the Maharashtra government intends to bring. The governor, not happy with this particular move made by the Maharashtra government, refuses to accept the date of election of the speaker as recommended by the government. This is where the author goes on to say that it raises couple of concerns in the case of Maharashtra. What are the concerns? One, when we look at the governor, yes, the governor has some discretionary powers. These are the discretionary powers which can be applied when the governor intends to in specific areas, but in most of the cases he has to listen to the cabinet. Since he is not abiding by the call of the ministers in this particular case, by not fixing the date, he goes against the principles of the constitutional government. Ideally, there is no role that is assigned to the governor when it comes to the election of the speaker or the deputy speaker. The only thing that he has to do is to assign a particular date on which the members assemble and they could elect their speaker. This is what it says, but in the constitution there is no reference to governor whatsoever. But in this particular case, since the governor is not ready to listen to the ministers, is not ready to listen to the government, he has violated the constitutional government principles, says the author. Added to this, when we look into Lok Sabha, the mode of election to select the speaker can either happen through the secret ballot or it can happen through a motion in the house as well. So the government in the state of Maharashtra also has the power to bring in new rules and may also select whether it is open ballot or it is voice vote. Why is the governor not respecting the viewpoints of the government in charge is the second major concern. Since the Constitution of India does not give any powers to the governor, and at the same time the government has the power to make changes in the rules as to declare the mode of operation of elections, since both of it is constitutionally right, since the governor is not doing it as per the request of the cabinet and the ministers, the author goes on to say that the government can bring about changes in the rule of operation so that they are entitled to this particular process. So basically he goes on to say that they can bring changes when it comes to this whole process and can ensure that this is passed on to the secretary. The secretary instead will not give it to the governor, but instead directly bring about the change where he will ask the assembly members to assemble so that there could be elections for the speaker. So the author goes on to say that the government has the power to bring rules and regulation changes, and such power should not be stopped by the governor, says the first part of the article. The second incident is in the state of Kerala. What is the issue here? We know from the fact that the governor of the state is the ex officio chancellor of the universities in that particular state. So we have the state universities. The state universities chancellor is the governor. Then we also have the vice chancellor as well. The vice chancellor is appointed by the government. There are different laws in different states. Let's say, for example, we take the example of Haryana. what happens in this particular place, we have the university laws. There are laws in place put out by the Haryana government as per their statute, which clearly goes on to say that the governor should appoint the vice chancellor not as an independent personality, but he has to abide by the rules and regulations, aid and advice of the cabinet. So in Haryana, the governor does not have an independent power to appoint the vice chancellor of a relevant universities. That is what the law says in reference to Haryana. But let's take the example of Kerala. In Kerala, what does it say? It says that the governor has an independent authority to ensure that he has the power to appoint the vice chancellor of the state. So it means in the state of Haryana, he has to listen to the aid and advice of the cabinet. But when it comes to the Kerala, the governor has an independent provision. He would be able to appoint the vice chancellor independently without the aid and advice of the cabinet of the state of Kerala. So that is the difference what is happening in the present situation. In the present situation, there was already an existing vice chancellor of the Kannur University. So what does the government do? The government makes a recommendation to the governor that, dear governor, we already have the vice chancellor, reappoint the same vice chancellor. So what is happening? There is reappointment of the vice chancellor to the Kannur University. So everything went good. Why? Because as per the University Act of Kerala, it clearly goes on to say that a person who is already a vice chancellor, his term may be extended, that is, he can be reappointed as well. So according to the University Act, it clearly goes on to say an incumbent vice chancellor is eligible for the reappointment. But after all this process was executed, we have the governor of Kerala who comes out in open and he makes a statement saying that he was under pressure from the government, and which is why he had to appoint the vice chancellor to the Kannur University. This is where the author questions this entire debate. Why does the author question it? That is because according to the laws of Kerala, there is a clear-cut independent stand which the governor can take. The governor in this particular case could have ideally taken his stand, but he complied by the words of the state government, and at the same time you also have the judgments made by the Kerala High Court in the Gopal Krishnan versus the Chancellor University of Kerala, where the Kerala High Court has clearly clarified that the governor would be able to act independently, but he did not do so, but instead he makes a criticism against the government, and this does not establish a healthy relationship between the state government and the governor, says the author. So in this particular case, the author goes on to say, taking into picture both these instances, one which happened in Maharashtra, the other which happened in the state of Kerala, what we are seeing is a drifting relationship between the governor and the state governments and the cabinet, and all that means is that the constitutional position of the governor is not meeting the demands as originally envisaged. When we look into the Constituent Assembly debates and much prior to that as well, before the Constitution of India, the governor had a lot of powers. The whole idea of the office of the governor before to the independence meant that he had absolute control over the province. But this was also being debated in the Constituent Assembly. The Constituent Assembly, you had two sets of people. They were into debates and deliberations. One set of people said that the governor should be given absolute powers when it comes to that particular state. The other set of people said that governors is just a nominal head. He should not be given all the powers. So you had one section of people who said that the governor should be as powerful as the colonial era governors, but you had Dr. B.R. Ambedkar who was clearly saying that the executive power of the state lies with the state government and the governor is just the nominal head. And finally, we did accept for the fact that the governor, yes, he has discretionary powers which is not accorded to the president. Yes, the governor would be able to apply these discretionary powers in exceptional circumstances, but this does not mean that he interferes with the objectives, the values and the application of the business of the state government. So whatever the state government says, says, that is the cabinet says, the same will have to be complied by the governor. If he does not comply, it is violating the constitutional principles, says this article. The same has also been confirmed by the Supreme Court of India in Shamsher Singh case up until Nabam Rabia case, where the Supreme Court has clearly said yes, the governor has the discretionary powers, but at the same time there is the executive power which is accorded to the cabinet, and the governor only has to listen to the advice of the council of ministers. The author also goes on to say that the governor in the near future will also have to listen to the cabinet. He has to take the aid and advice of the council of ministers, and ultimately the constitutional office should maintain its dignity, says the author. He goes on to conclude that Pandit Thakur during the Constituent Assembly debate says governor will be a man above party, and he will look at the minister and government from a detached standpoint, which means he has to remain neutral and he should not be interfering with the work of the cabinet, which is not happening in the present situation, says the author. It is this that we have to understand in reference to this article. Now let's look into the next article. This is another link article to the first article. What does this speak about? As we just discussed, there are few states in India which has clearly pointed out in its laws that the governor will have to listen to the advice of the council of ministers when he is appointing the vice chancellor to the state universities. There are other set of states in India which also says that the governor has an independent stand. He would be able to think independently and also appoint the vice chancellor of a relevant state university, in what could be another friction between the governor as well as the state assembly. What we are witnessing is in the state of Tamil Nadu. So in the state of Tamil Nadu, they are planning to bring changes in the rules so that all these powers that are given to the governor when it comes to the appointment is taken away, and the governor listens to the cabinet when it comes to making the appointment to the vice chancellor. So they are planning to take up the Haryana model instance where we did discuss about it. So in this particular backdrop, what the author also says is that whenever there is appointment of the vice chancellor that takes place, what is important is the transparency. So if the person is capable enough and that is on the basis of merit, so such a person should be appointed as the vice chancellor. So this whole conflict between the governor and the cabinet should be resolved, and the law should be clear in itself, says this article. Now let's look into the next article. This article says a bill that could alter the mediation landscape. The article here is speaking about the mediation bill. When we look into the judiciary in India, there are a lot of cases in the Indian judiciary. There are crores of cases when we take from the lower subordinate level judiciary, subordinate courts to the high courts to the Supreme Court. There are large number of cases. When there is large number of cases, it means there is pendency. When there is pendency, it also means justice delayed is justice denied. In order to overcome this particular issue, we have the Chief Justice of India in the India-Singapore Mediation Summit in 2021 said that mediation should be made mandatory as a first step in dispute resolution. So what is this dispute resolution? We have something called as the litigation, where you have two parties, one the petitioner, the other happens to be the respondent. So these two people who are not happy with each other, they have a controversy, they have an issue in dispute, approach to the court of law. Why? Because the court of law will resolve their queries and ultimately provide justice to them, ultimately also provide the judgment, so that this acts as a relief either to the petitioner or to the respondent. But if it goes to the court of law, it takes a large number of years. Why? Because there are already number of cases. So an alternative to this is what is called as alternative dispute resolution system, or what we call as ADR. As part of the ADR, one of the process happens to be the mediation. So in mediation, they do not go to the court of law. Instead, you will have two parties, one a petitioner, the respondent, one who's making a claim, the other who has to give this particular claim. And what these parties do, they select one neutral person called as mediator. So instead of going to the court of law and filing a case, these two parties select one of the mediator who is neutral in itself, they approach the mediator, and it is the mediator who will pass what is suitable for both the parties. So he will listen to both the parties and ultimately he will make a conclusion. So if this particular conclusion is satisfied by both the parties, they enter into this agreement, and such an agreement will be in the written form and they will execute such an agreement. So what is happening here in this particular issue? There is a dispute, there is a controversy, there is a claim that one of the parties is asking for, but instead of going to the court of law, what do? They take up to the route of mediation, which is an alternative dispute resolution, and ultimately their issues get resolved. So we have the Chief Justice of India who also says that when it comes to such cases, they have to first go through the process of mediation before approaching the court of law. So what are the advantages? One, they would be able to select the mediator that they are comfortable with, and at the same time it will not take a lot of time as well, and at the same time the cost will also not be too much as well, and this will also mean that justice or this whole cases is resolved as soon as possible, and they don't have to go to the court of law endlessly for number of years. In order to promote this whole idea of mediation, we have the government of India which has now introduced what is called as the mediation bill of 2021. So what is this mediation bill? Why has the government come up with its introduction? That is because when you look into the present setup, we have the mediation which is being spoken in the Code of the Civil Procedure of 1908, the Arbitration and Conciliation Act of 1996, the Companies Act of 2013, the Commercial Courts Act of 2015, the Consumer Protection Act of 2019. So you have different laws which speaks about mediation. So all these laws are in a disordered form. So it means that if a person has to go through the process of mediation, he has to refer to multiple laws in picture. There was no standalone legislation, a single legislation to where to refer to in order to overcome all these issues, so that we have one single law which speaks about the mediation. The government of India has introduced the mediation bill. So the mediation is nothing but a form of an alternative dispute resolution where two parties, one happens to be the petitioner or a claimant, the other happen to be the respondent, attempt to settle all their dispute outside the court area. So they're not entering the court because all their issues will be sorted outside the court with the help of an independent mediator. So the mediator will be appointed as both the parties discuss about one single neutral person. So with this particular introduction, what would happen? With the introduction of the mediation bill of 2021, it will promote mediation. So since it is promoting mediation, it can be physical in form where parties sit amongst each other, they also discuss about this particular issue, or it can also be online dispute resolution as well. Since we are living in a technological era, many people would be staying in different places. I might be staying in Bangalore, I might be staying in Mangalore, I might be staying in Mumbai, I might be staying in Chennai, the other party may also be staying in Delhi, Kolkata, so on and so forth. They may not be able to meet physically as well. In that particular case, they can also go for the online dispute resolution with a neutral mediator. So this particular mediation bill promotes mediation on a physical level. It also promotes at the online level, and when they reach a consensus or broad conclusion is reached, what they will enter is into an agreement, and this agreement should be in a written form and such will be executed. So what is the applicability of this mediation bill? All parties who reside in India or whose offices are incorporated in India or have their place of business in India, such can look into this mediation. And at the same time, if there is an international mediation where one of the parties happen to be a foreign government or a foreign national or a resident or an entity with its place of business outside India, such is what is called as international mediation. Such a case can go to the mediation and they would be able to settle their differences and amicably come to a conclusion. So this is where this article speaks about what is called as the pre-litigation mediation. What is this pre-litigation mediation? So as we just discussed, pre-litigation mediation is nothing but before they head to the court of law, they would be discussing. That is what is called as pre-litigation mediation. When you look into the earlier acts, we did discuss about different acts, right? So these acts had different words when it comes to the mediation. It can be called as mediation, it can be called as pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import. All of this under this particular legislation is simply called as mediation or the pre-litigation mediation. So this mediation bill goes on to say that before they approach to the court of law, they have to try to settle the dispute by the mediation before approaching the court of law. However, if there is any dispute which is likely to affect peace, harmony, tranquility amongst the residents or families of any area or locality where large number of interests have to be met, in such a case what you can also go through is called as the community mediation. So if they have to go through the community mediation where large number of people are involved, the consent of the parties will also have to be taken. So one is happening at the individual level, the other is happening at the community level. If it is able to meet the interest of both the parties, the consent is also taken. In such a case, community mediation is also encouraged as per the mediation bill of 2021. Now the important question is, will all disputes come under the mediation? No. Which are the ones which are exempted from it? Relating to claims against the minors or persons of unsound mind. If there are minors or unsound mind, if they are not able to make decisions, they are less than 18 years of age, such will not come under the mediation. Why? Because they would not be able to take an independent stand, they would not be able to take a consensus, they would not be able to reach an agreement, which is why such is taken or given an exemption. Added to this, involving the prosecution for the criminal offences. Can criminal cases go to the mediation? The answer is a clear cut no. Why? Because let's assume there is a murder that has happened. In this case, the person has lost a life, the family members are grieving about it. So if the family members are either threatened or they're given money or there is some other threat indirectly given to it, they can also enter into the mode of mediation and they can also withdraw the case. These people can also be poor as well, they may not be able to run the cases for couple of years. So in all these cases, which includes the criminal offences, in such a case what we require is mediation not being given permission to. So mediation is not given permission for the criminal cases, which means something like the murder or the rape which has happened against the society, happened against the state, such cannot be given permission, says the mediation bill. Then affecting the rights of the third parties, this is again exempted. Relating to levy or collection of taxes, this once again will not come under the bracket of the mediation. Added to this, the central government over a period of time would also be able to amend the list, so it would be able to add or remove such things from those which can be settled under the mediation or not. Added to this, if there is a particular incident which is civil in nature but has the potential to create a law and order situation, such can also not come under this particular mediation. Apart from this, in case it is about the sexual harassment of women at the workplace, this is also kept outside the scope of the mediation. That is because you already have the internal or the local complaint committee which is looking into it. They will fix the issue and the mediation cannot take place in such a process. So basically, when we speak about the mediation process, this entire mediation process will be confidential in nature. This will not come out in the public forum. The confidentiality will be maintained, and at the same time such a process should be completed within 180 days. If it is not completed within 180 days with the consent of the parties, it might be extended by another 180 days, says this particular mediation bill. However, when they reach a consensus, they reach a conclusion, what we have is a mediated settlement agreement. So agreements resulting from the mediation must be in writing, signed by both the parties who have taken up to this particular mediation, and this should also be authenticated by the mediator. So such an agreement will be final, binding, enforceable in the same manner as that given by the court judgment. However, if we are able to prove to the court of law that there has been some fraud or corruption, impersonation or disputes that has not been able to meet the justice, in such a case they can also approach the court of law. So what are the advantages of the mediation bill? Basically, there will be trained mediators, service providers will be given a clear-cut structure about it. What we also have is an online dispute resolution. What we will also have is a process that is established through this particular law. Previously, there were multiple laws, lot of ambiguity and confusion. Now, what we have is a process that is established, and in the near future, we will also be transforming into an online platform. So the mediation will ultimately reduce the number of pendency cases in the court of law, and ultimately all that this particular law will provide is a structure so that all these disputes can be settled amicably. It is this that we have to understand in reference to this article. Now let's look into the next article. This article says control rather than privacy. The article here is speaking about the privacy issue. It is speaking about data protection. Much prior to the Puttaswamy judgment and much prior to the Justice B.N. Sri Krishna Committee report, we did not have any of the laws which spoke about the privacy in specific. It was only at the mercy of the companies and the government. We did not have any privacy law, but it was Puttaswamy judgment which became a landmark judgment which spoke about privacy of an individual and protection of his or her data. In order to protect his or her data, we have the Government of India which appointed Justice B.N. Sri Krishna Committee. So this Justice Sri Krishna Committee report further gave rise to the Parliament coming up with the legislation in the form of Personal Data Protection Bill. So the legislation meant that since it is the most important aspect related to fundamental right, under Article 21, which speaks about right to life with dignity, which speaks about privacy, this cannot be just pushed across. So what it required was a joint committee looking into the proposals of this particular legislation. So the joint committee has looked into the proposal, that is the Personal Data Protection Bill, and it has also given its report, but this report is not meeting to the original demands, says this article. So basically the article goes on to criticize even the joint committee report. Why does the author criticize the joint committee report? That is because when it is being referred to the joint committee, it was ideally envisaged that it look at all the loopholes in the Personal Data Protection Bill. It will also ensure that there is equality between the government as well as the private authorities, and at the same time it will take care of the privacy of the individuals. But in this particular case, what has the joint committee report done? It has clearly categorized the authorities into government and private. All the restrictions with respect to data have been put up on the private authorities or the private organizations. The same is not present for the government. Why? Because for the government, the joint committee once again has given some exceptions. What are these exceptions? We have clause 12. We also have clause 35 as well, where according to clause 12, if the government feels that there is a particular person who's taking the subsidy from the government or it is required for the functioning of the government, in such a case the consent of that particular person with respect to his data need not be taken. So clause 12 clearly goes on to point out that the consent of that particular individual is not required for the functioning of the government. That is the first issue. Now what about the investigating agencies? The investigating agencies are also given exemption as well. These investigating agencies of the government, if they feel that they require the data of a particular person, the personal data of an individual, the same can be taken up without the consent of that individual. So ideally, the joint committee report should have balanced both the private organizations and the government, but it has given exemption to the government, which means the government is enforcing a surveillance state. Added to this, when we speak about the organs of the state, we have different organs or the branches of the state. One is what we call as the legislature. Next, what we call as the executive. Third, what we call is as the judiciary. Apart from these three organs, there is one of the institutions which is equivalently important. That happens to be what is called as the fourth branch institution. What is this fourth branch institution? Let me give you an example. You have the UPSC. You also have the Election Commission. You also have the National Human Rights Commission as well. When it comes to democracy in India, which is one of the aspects of the basic structure, what would happen? We need the periodic elections. So who will ensure that there is periodic elections, free and fair elections? It is the Election Commission of India. If a person's human rights are violated, whom can we approach? It is the National Human Rights Commission or the State Human Rights Commission. So such bodies are called as the fourth branch institutions. So these fourth branch institutions play a very critical role, play an important role in executing the constitutional values. So we speak about a constitutional value called as democracy, we speak about impartiality, we speak about equity, we speak about justice, freedom and human rights. It is not just given on the bare acts of the constitution. You need an authority which is implementing it. So such an authority which is implementing all these constitutional values is what is called as fourth branch institution. They essentially will also have to be at an arm's distance from the executive, which means even though we have the Election Commission of India, it is completely independent of the authority of the government. Similarly, when it comes to privacy, what we have is one of the institutions. So we have the data protection bill. The data protection bill also has an authority so that the privacy of an individual can be restored, so that it can be maintained, and such an authority which is ensuring the implementation of the personal data protection bill is what is called as data protection authority. So when it comes to the data protection, we have the fourth branch institution called as the Data Protection Authority, which will ensure that the privacy of an individual is kept intact. So what is this Data Protection Authority? It is this particular authority which will implement the provisions of the bill, protect the interests of the data principles, prevent any misuse of the personal data, ensure that this particular bill is complied by all the organs, that is the government as well as the private organizations. So basically it is acting as a bulwark against the unconstitutional and illegal use of the personal data of the citizens. But this is where the author goes on to say that there are concerns with respect to the Data Protection Authority. Privacy is a very important fundamental right. It is guaranteed as part of Article 21. So will a single authority, that is a data protection authority, would it be able to discharge all the functions under this particular legislation? Is the first major question asked by the author. Since it is more about privacy, it is about managing the government and the private, it is also about managing multiple areas of privacy related issue, a single authority would not be able to manage. So the author says a single authority will not be able to discharge so many functions in an efficient manner. Added to this, whenever you are making an appointment, let's say for example you're making an appointment to one of the authorities. So whenever there is an appointment, what should happen? It should be completely independent appointment. So you would have the government, you would have the prime minister, you would have the cabinet ministers, you would have a member from the judiciary, you would also have a member from the opposition as well. But when it comes to data protection authority, according to Sri Krishna committee, it said that judicial overlook should be present when it comes to the appointment. However, when it comes to the joint committee report and the personal data protection bill, more powers are given to the government. Clause 86 says that authority should be bound by the directions of the central government under all cases and not just on questions of policy. So in this particular backdrop, since clause 86 clearly points out that a person appointed by the government will have to listen to the government, will he be able to act independently is the second major question. On one side, the appointment is a problem. On the second type, there has to be judicial overlook, says the Sri Krishna committee. But according to this particular bill, the appointment procedure is by the government, which means the person appointed will comply to the government orders and will not act independently, is the second major concern. Further, the author also speaks about the non-personal data. Let's say there is an organization which is holding on to the non-personal data. Let's assume for a moment this happens to be an MSME company. If the government requests such non-personal data, the same will have to be given by this particular MSME sector or that organization. So basically, it means that they have to hold a lot of data, which means they require advanced technology, which means they require technical profits, and at the same time, if they have to transfer such data from their website to the government, it will also become an expensive one. So on one side, we are speaking about empowering the MSME sector, but on the other side, because they have to hold on to the data, it will become an expensive process, says the author. So going forward, if this particular legislation has to be passed, all the loopholes that are present in this particular legislation will have to be looked into. A thorough reading will have to be done. These loopholes will have to be abridged, says the author. It is this that we have to understand in reference to this article. Now let's look into the next article. This article says the best masks to ward off the Omicron. The article here is just making a reference about different types of masks that we currently have. We have the surgical mask, we have the cloth mask, we have the N95s. So this article is just for the informational sake. So all that you have to do is just skim through this article, which clearly goes on to point out that we have different types of masks in place and which is the best, so that we would be able to use that to prevent the spread of the Omicron virus. All that you have to do is just skim through this article, and it is not that important from the examination point of view, but from the knowledge perspective and also from the awareness perspective and also from the health related issues, this becomes important. So kindly skim through it. Now let's look into the mains practice questions. The governor, as a constitutional authority, should be a friend, philosopher, guide to his government and not run a parallel government. In the light of the statement, examine the discretionary powers of the governor. The mediation bill has the potential to relieve some of the pressure on law enforcement agencies. Substantiate. So please write all your answers on the comment section, peer review, and do give positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.